a monumental and momentous decision that has been taken by the High Court, the Allahabad High Court to be precise. Viewers, 5 petitions were filed by the masjid side, by the UP Sunni Central Waqf Board and the Gyanvapi Mosque Committee. In these petitions, these petitioners had held that a suit filed in 1991 over the Varanasi Mosque or the Gyanvapi Mosque is not maintainable because it is barred under the provisions of the Places of Worship Act 1991. Viewers, had their plea been heard and had their plea been accepted, the man in the middle of your screens, Vishnu Jain, who is representing Hindu petitioners, he would not be able to show his face today in public, viewers, because it would have constituted a massive setback for the Hindu side. But the reverse has happened. The High Court has accepted the arguments of the Hindu side, rejected the arguments of the Waqf Board and the Gyanvapi Mosque Committee, and have said that the pursuit of justice by the Hindu side in determining the character of this place of worship, whether it is a temple or a masjid, is legitimate, it's valid. And therefore, viewers, today, viewers, it is a momentous day. Many people have been saying that the Places of Worship Act stands in the way, but the judge was very clear. He said that the Places of Worship Act only applies to those who are trying to convert a place of worship into something that it is not, i.e., a temple being converted to a mosque, or a mosque being converted to a temple, or a mosque being converted to a church, or vice versa. Here, the High Court was very clear. The Gyanvapi complex cannot have a dual religious character, and that the 1991 Place of Worship Act doesn't bar anyone from determining the character of a place of worship, i.e., whether it belongs to one denomination or the other denomination. And therefore, viewers, the High Court judge has set aside the pleas that were filed, the 5 pleas that were filed by the Waqf Board and the Gyanvapi Mosque Committee, delivering a setback to the Muslim side, viewers, which means that the survey will go on here in Gyanvapi to determine whether this is actually a temple that was subsumed and on top of which a mosque was built by force by Aurangzeb's farman. And what better way, viewers, than a scientific archaeological study of the facts to determine the character of this place of worship. Viewers, this also has implications for the case in Mathura. Just recently, a court had ruled that the ASI could go ahead and conduct a court-monitored survey of Mathura, of the Eidgah mosque there, because that is also thought to have been built at the exact place where a temple stood marking the birthplace of Lord Krishna. This has far-reaching implications, viewers, and we need to discuss them in a cool manner because, as the court says, this has consequences for community relations between Hindus and Muslims. And the speedy resolution of this entire issue is in the national interest. Viewers, a deadline has been set by the court to resolve this entire issue, which has been hanging fire for centuries. And we have with us the peerless J.S.I. Deepak, senior advocate of the Supreme Court and author, and Adil Hassan, spokesperson of the AIMIM. And I want to first begin with Mr. Adil Hassan. Mr. Adil Hassan, there's now no doubt about it. The Hindu side is vindicated. It has a right to investigate the character of the structure that we are seeing, whether it was actually built by force on a temple or not. A scientific inquiry is being conducted. And I want to ask you now, sir, very simply, fundamental question. Why are you opposing a scientific inquiry which will get to the truth? Are you afraid of the truth, sir?
बड़े भाई, nobody is afraid of the truth. The reality is that the 1968 में जब आप दोनों पक्षों के बीच समझौता हो गया था, जब दोनों पक्ष तैयार हो गए थे 50-55 साल बाद, ऐसी क्या बात होगी जो आप इस चीज का मामला आप उठा रहे हैं? आप ही खुद बताइए, ऐसा क्या मामला जब दोनों पक्ष जो बड़े बुजुर्ग ने समझौता किया था तो देश ने माना था, उत्तर प्रदेश ने माना था।
नहीं,
ऐसा तो नहीं है कि हिंदू
आदिल हसन साहब, आज की डेट में ये आप रेटरिकल सवाल नहीं कर सकते, क्योंकि कोर्ट ने तमाम आर्ग्यूमेंट्स को मद्देनजर ये फैसला सुनाया है. The court, in all its wisdom, are you doubting the court's wisdom?
मेरा ये कहना है, हमारा साफ कहना है, 9 जनवरी को सुप्रीम कोर्ट में मामला था, तो इतनी हड़बड़ी क्या थी? ऐसा कौन पहाड़ टूट रहा था जब हिंदू और मुसलमान?
तो आप ये नहीं समझते कि कोर्ट ये सब आर्ग्यूमेंट्स कोर्ट ने क्या नकार दी क्या? आप ये कह रहे हैं, एक मिनट, just 1 minute. Let us get a legal opinion on this. 1 minute, open this up. Let's get a legal opinion. 1 second, sir. Let's get a reasonable. आप rhetorical बात करेंगे. J. Deepak will talk facts. First of all, what is your takeaway, Mr. J. Deepak, of what the court has ruled today?
See, one of the things that people haven't actually made sense of is the basis of the filing of the suit with respect to the Gyanvapi Mosque. And Vishnu, who's a good friend, has actually done his homework. He's read through the Place of Worship Act properly. And I think as is available under Section 4.3, to the best of my memory, of the Places of Worship Act. Because it basically says that if you're able to prove that any structure or any place of worship, so to speak, its antiquity is over 100 years, or it is treated as a heritage structure within the meaning of the 1958 Antiquities legislation or the archaeological legislation, then the provisions of the Act or the bar under the Places of Worship Act shall not apply. Okay, so that is the fundamental basis of the suit. Now, once you're able to establish, and you'll be able to establish only when you actually get a survey done, and therefore a survey is a precursor to the establishment of that fact under the provision of the Places of Worship Act. That's the first step. So there can't be an objection to the appointment of any advocate commissioner or any commission to undertake an archaeological survey of the area in question. That's point number 1. Point number 2, once you establish this, or even if there's a prima facie case established, then it is possible, rightly so under the legislation, to seek the right to worship for Hindus as well, or rather primarily for Hindus, because once you're able to establish that this was a place that has been claimed and we are trying to reclaim that the place, so to speak, then the bar under the Places of Worship Act, that you cannot change the character of the place, its religious character, so on and so forth, none of those bars would apply. Okay, so what the High Court has done is to first respect the trial process, which is that all your arguments you will raise before the court of first instance, which is the trial court. Go back and fight there. And 2, the validity of the prayers, the legitimacy of the prayers, all of them will be tested by the trial court. So in this matter, if you notice, the number of times this matter has gone to the Allahabad High Court and then the Supreme Court, it's almost as if every order that's passed by the trial court is the subject of an appeal, only to be repeatedly told by the higher fora that respect the trial process. Let there be a final decision that's taken by the trial court before the appellate court looks at it or before the Supreme Court looks at it. So I think the message that's gone to the defendants in the matter or the opponents of the plaintiffs in the matter is, do not take the system for a ride and do not try to circumvent the process of trial in the first place.
Do not take the system for a ride, Hassan Sahab. आज कोर्ट ने आपको ये क्लियरली बता दिया है. अब ये सब वॉट अबाउटरी बंद कीजिए और सीधा सच्चाई की तरफ बढ़िए, और वो सच्चाई, दैट ट्रूथ कैन ओनली कम आउट थ्रू ए साइंटिफिक इंक्वायरी. व्हाट इज योर प्रॉब्लम विथ समबडी डिटर्मिनिंग द कैरेक्टर ऑफ दिस प्लेस?
राहुल साहब, आप ही बताइए, 1947 में जो भारत के संविधान निर्माता डॉक्टर बाबा साहब अंबेडकर हो, सरदार पटेल हो, पंडित नेहरू हो, सब मिलके जो कहा था कि 1947 के वक्त में जो रिलीजियस स्ट्रक्चर था वो उसी तरह रहेगा.
अरे वो उस टाइम नहीं कहा था उन्होंने, 1991 में ये लॉ आया. प्लीज जानने तो जाइए.
लॉ लॉ 91 में आया, लेकिन 1947
नहीं, किसी ने नहीं कहा सर, नहीं, सोमनाथ का रिकंस्ट्रक्शन हुआ था 1940, नहीं, राजेंद्र प्रसाद साहब खुद गए थे इनॉग्रेट करने, आपको कुछ हिस्ट्री ज्योग्राफी को पता ही नहीं है।
लेट मी स्पीक। अरे सब पता है,
आप गलत बात है,
क्या बीजेपी का जैसे आप ही को आता है क्या सब?
देखिए, आप ऐसे मत बोलिए,
नहीं,
आप गलत बात कह रहे हैं, आप लोगों को भड़का रहे हैं, भड़का रहे हैं।
No, let me speak. No, let me speak.
No, you need to
no,
speak.
Let me speak.
Come
let me
clear.
Speak. You can't interrupt like
come
this.
Clear.
No, you can't interrupt like that.
How?
No, if you want to discuss on BJP agenda, then
Mr. Hassan,
no, it's
the courts are not.
Your words on my mouth.
Okay, see, viewers, when people don't have enough to say, when they don't know what to
I
say,
am ready to,
they will start attacking people.
I am ready to answer.
They will start.
You don't put BJP agenda on me.
No, there's no BJP.
I know your agenda. I know your agenda.
Yes,
Please,
absolutely.
Don't put BJP agenda on me. My point is clear. My point is clear.
Listen, I'm not going to give space to you if you keep calling. No, if you're going to constantly impugn people.
Okay,
that's not the way.
I will not join your program.
You need to be factual, Mr. Adil Hassan.
Be happy with your program.
Roiye mat, sir.
No.
Take an informed view.
You can't dictate your terms.
Don't become petulant. Take an informed view, Mr. Adil Hassan. I'm asking you a simple question.
I know.
What is the problem in determining, the Places of Worship Act 1991 only prevents the conversion of a place. It does not, and no one is here converting the place. It only very pointedly talks about somebody who wants to convert a place. No one is converting the place. All the petitioners on the Hindu side are asking is to determine whether this is a masjid or whether this masjid was fraudulently built upon a temple. इसमें क्या हर्ज है?
अच्छा, what about 1968 agreement then?
Sir, that was between the wrong parties. The court has gone into this and it has nothing to do with, you are talking about the merits of the case. They will be looked at later. Okay, 1 minute. Let me bring in, on this point, let me bring in, on this point, let me bring in Jaisai Deepak. Okay, he's not a BJP man. I'll ask him. See, the claim by Mr. Hassan is simple, that the Places of Worship Act 1991 still stands in the way of reclaiming the places of worship. Have the courts, in your opinion, done enough to resolve this, or is there more to be done?
So, Rahul, I think the first opening line of your statement that the Places of Worship Act stands in the way of Hindus reclaiming their places of worship, I agree with the sentiment behind the question. However, allow me to say this, that a closer reading of the legislation would reveal that if conditions are satisfied, which is the condition under section 4.3, if it is satisfied, then your ability to reclaim is certainly not barred by the act itself. So the act has a certain prescription or a certain prohibition, or proscription, so to speak, and there is an exemption from the prohibition also. So there are two ways of looking at the legislation. Either you say that the entire legislation is unnecessary because it effectively creates some kind of an impediment, ability to reclaim our places of worship, even through a legal process, just as in the Ayodhya case. Because why should an exception be created in the legislation exclusively for the Ram Janmabhoomi dispute when there were similar disputes pending and continue to be pending? That's one. The other thing is, even as the legislation stands, what are the windows available within the legislation which facilitate and enable reclamation? That is the entire, let's say, sum and substance of Vishnu Shankar Jain's petition or his suit before the trial court in Uttar Pradesh on the question of the Gyanvapi Mosque. But I do agree with the larger sentiment that when the BJP was in the opposition in 1991, its representatives had taken a very categorical position against the passing of this legislation on the ground that it does grave injustice to the faith system which is native to this land. They've taken this position. Now, after the filing of the petition in the Supreme Court challenging the Places of Worship Act, it is slightly baffling that no affidavit has been filed by the central government yet, to the best of my limited memory at this point, despite multiple opportunities being given to tender an affidavit or file an affidavit explaining the union's position with respect to the legislation, its legality, its constitutionality, its necessity, so on and so forth. So, at the very least, I would expect the government to place its position on record so that we know what is to be expected once the proceedings start and once the hearings in the petition begins. So it's easy to say that the Supreme Court hasn't done enough, but the Supreme Court has given multiple opportunities to the union government to place its position on record. If the union does not place its position, what is the Supreme Court expected to make of it? After all, it is expected to defend the central legislation.
Well, viewers, you've heard it from an authority who's written on this particular issue. He's cutting through all the rhetoric.